the right to information. Okay, we will start with something called the right to information. When we discuss right to information, we will first try to understand what is right to information. Second, is right to information a fundamental right? This is also important for the pre because you may get a technical question. We would then understand the evolution of right to information. We will then look at number 4, who can file a right to information. Then we will be looking at who implements right to information. So we will be talking about PIOs, your public information officers. We'll be looking at state information commissions. We'll also be looking at central information commission. Okay. Once we are done with this, we will look at certain current affairs developments. And in these current affairs developments, we would be looking at the RTI amendment, which happened very recently, which has also been a matter of grave public debate because it seems to dilute the powers and the independence of our information commissioners. Okay, so let us start. First, what is right to information? Okay, to understand this, one must look at things fairly clearly. One of India's most respected judges, Justice P.N. Bhagwati, once very clearly said, when a society has chosen to accept democracy as its creedal faith, when a society has chosen to accept democracy as its creedal faith, it is elementary that the citizens ought to know what the government is doing. Okay? Where a society has chosen to accept democracy as its creedal faith, it is elementary that citizens ought to know what the government is doing. Such a quote by Justice P.N. Bhagwati lays an incredible context to understanding what the right to information is. We've discussed this previously also. The citizens share what is often called a social contract with the government, where the citizens surrender their autonomy, their individuality, in the form of votes and taxes. They surrender the votes and taxes in favor of the government. The government processes those votes and taxes and in return provides security and welfare. So in one way, if you look at it, governments exist because citizens allow the government to exist. And that is one of the fundamental reasons as to why the right to information becomes important. Because the citizens have essentially created the government. And if the citizens have created the government, if the government runs because of us, the preamble says we as the citizens of India are the ultimate sovereign, then in such a case, we as the citizens of India have the right to know what the government is up to, because we have created the very government. So the right to information, or the freedom of information, or the right to know, as it may be called in other countries, is basically a tool to ensure transparency between the government and the citizens, is to ensure that the idea of governance, the idea of governmental functioning, is not opaque in nature. So it is a tool that allows us to actually get informed about the various activities of the government. So that is largely what is meant by RTI. Now the big question is, is RTI a fundamental right? Now you will understand that the Supreme Court is a final interpreter of the Constitution. There have been several cases through which the Supreme Court has given the status of fundamental rights to several issues. For example, you may remember a recent Supreme Court judgment of Puttaswamy versus Union of India, in which the Supreme Court gallantly said that the right to privacy is an implied fundamental right under Article 21. If the right to privacy is an implied fundamental right under Article 21, then the right to information is also an implied fundamental right, but under Article 19, the freedom to speech and information. This, for the first time, was given in a Supreme Court judgment called State of UP versus Raj Narayan. Then in S.P. Gupta's case, in Bennett Coleman case, in Hindustan newspapers case, there have been several Supreme Court judgments where the Supreme Court has kept on saying that no, it is a fundamental right, it is a fundamental right. And in fact, you would be very, very interested to know that in the state of UP versus Raj Narayan's case, and this case dates back to 1975, in 1975 itself, the Supreme Court had declared the right to information as a fundamental right. But it took decades and decades for us to actually come up with a law that implements a Supreme Court judgment, which is called the Right to Information Act of 2005. In the same way, the Supreme Court has said that the right to privacy is a fundamental right under Article 21. The government is still yet to pass the data protection bill, which would guarantee a sense of digital privacy and digital security to citizens, to organizations, as well as the government. So that's the larger idea. Now, you must understand that right to information is a fundamental right, period. Which means if you ever get a question in the prelims which says which of the following is true about right to information, or is right to information a legal right, a constitutional right, a statutory right, or a human right, your answer would always be a fundamental right. Despite the fact that the right to information was considered to be a fundamental right, it took many, many years for the government to finally execute this into action. Okay? So that's the larger context to whether right to information in India is a fundamental right or not. Okay? But let us also take a minute and figure out, how does the right to information as an idea come about? Is it an Indian idea, or is it something that was happening all across the world? And how did India decide to actually do this? So historically speaking, the first ever resemblance of an RTI law, a freedom of information law, actually goes back to as early as 1766 in a country called Sweden, where the king of Sweden essentially passed an order and wanted the people of Sweden to know what the king of Sweden was up to. And in 1766, it was not even a democracy. So whether it's a democracy or not, the people should have a right to know what their rulers are up to. From 1766 till 1966, for 200 years, you did not see any major movement, any major upgradation in the field of RTI. In 1966, the United States enacted the second RTI law of the world. And when the United States did it, several other democracies also started doing it because it made sense. So Norway, Australia, New Zealand also enacted the RTI laws by about the 1990s. So by early 1990s, early mid-1990s, quite a few, not all, a significant number of the major Western democracies decided to have an RTI law, and they did. Now, in the year 2000, how you have the United Nations for the world, you have the European Union for Europe. How the United Nations has documents such as the Universal Declaration of Human Rights, the EU also has documents. One of those documents is called the EU Charter of Fundamental Rights. And the EU Charter of Fundamental Rights in 2000 was released. It was basically a list of rights that the European Union wanted countries to give to their citizens, and in one of those rights, the rights to access documents was mentioned. Now, that gave a major push to the RTI movement all across the world. Now, by the late 1990s, several Asian countries also, such as Afghanistan, Kazakhstan, Bhutan, Maldives, they also had their own versions of RTI laws. But India did not have a national RTI law. So historically speaking, the world recognized RTI laws much before India did. And that's a very interesting way to actually look at it. The world recognized RTI laws before India did. And in India, RTI becomes a particularly fascinating study because the states of India, the provinces of India, a few of them at least, had set up their own RTI acts before even the center consolidated it. Information is a domain of the concurrent list, which means both the center and the states can make law on it. This also means if there is no central law on it, then the states can have their own law of it. The story of this began actually in Rajasthan, around the time where land reforms were being executed all across the country, where the government had placed a ceiling or a limit on the amount of land people in our country could hold, despite the fact that for a long time the right to property was a fundamental right. This is also one of the reasons why contemporarily or the most landmark judgments such as Sajjan Singh, Shankari Prasad, Golaknath and Keshavananda Bharti also happened. But coming back to RTI, when this happened in Rajasthan, this eventually led to a lot of protests and a lot of demonstrations because the government was not disclosing the property papers transparently to the people. So there was an organization called the Mazdoor Kisan Shakti Sangh, which organized and was one of the key faces of this movement. And that is how RTI was born. Several years later, in 2005, the government tried doing this before also. But in 2005, India finally had the Right to Information Act, an act that implements an implied fundamental right. How Article 21A is right to education gets implemented through the Right to Education Act. One of the things that Article 19 also means is the right to information. Now you must have a question, sir, why does the right to information have anything to do with Article 19? Because Article 19 Clause 1 talks about the freedom of speech and expression. If you have, as a citizen, have a fundamental right of the freedom of speech and expression, then you also have a right to be informed before you speak or express yourself. If I do not get the information that I need, then I'm not able to express myself properly because my information is limited. That is why the right to information was an implied fundamental right under Article 19 and not any other fundamental right. Now, this answers evolution, okay? Now, the next question is, who can file RTIs? Now, as we figured out, the right to information is available as an implied fundamental right under Article 19. We know that under Article 19, these rights are not available to foreign citizens. If Article 19 is not available to foreign citizens, then anything implied under Article 19 may not also be available to foreign citizens. That is why ordinarily an RTI is available only and only for an Indian citizen. Only and only for an Indian citizen. Okay? Now, you must understand the legal context to this. What does the RTI do? What is the larger idea behind this? And let's listen to this. Okay? So our first question now becomes, when you're looking at implementing the RTI and stuff like that, let's understand this. Our first question is, what does the RTI do? Now, because of the Right to Information Act 2005, public authorities, which means an authority under state, Article 12, are required to make disclosures on certain aspects of their structure and functioning. They have to inform the people about what they do, how they do something, and why do they come to a decision that they take. So what kind of disclosures does the RTI Act mandate public authorities to do? These disclosures would mean, 1, a disclosure on their organization, function and structure. A disclosure on their organization, function and structure. 2, the powers and duties of its officers and employees. And 3, financial information. So the right to information mandates public authorities to disclose primarily 3 kinds of disclosures. 1, a disclosure on their organization, functions and structure. 2, the powers and duties of its officers and employees. And 3, financial information. Okay? Now, these are disclosures that have to be made suo motu. Right to information is a twin right. You can ask the government to disclose certain information, and the government, even before you ask that information, must keep that information available to you. That is why you would have seen FAQs on ministerial websites, or contact us, or organizational structure, or who's who, or about us on ministerial websites, because that's a mandatory disclosure. And these are the 3 disclosures. The disclosures that you have to voluntarily disclose, even before somebody asks, as we've discussed before, are disclosures on organization, functions and structure, powers and duties of their officials and public and employees, and 3rd, financial information. The intent of such suo motu disclosure is that the public should need minimum recourse through this act to obtain such information. So the obvious idea was, if you are already giving information that would usually be asked, it is like setting up an FAQ, a frequently asked question. You will see most websites, Amazon, Flipkart, if you're buying something online, anything, you'll all see FAQs. That, do you have a problem logging in? Is your problem with the OTP? Is your money being debited from your debit card but it has not shown you as so? So those are FAQs, because most people will ask the same question. So this is to ensure that the disclosures are made suo motu, so that there is lesser dependence. People do not have to file an RTI application. They don't have to file an application to the government if the information is already available. If such information is not made available, then citizens have the right to request for it from the authorities. Okay? This information may include information in the form of documents, files, electronic records from the authorities. Okay? Do we understand this? Which means, if the organization is not disclosing the information beforehand, if the person cannot find it beforehand, then a citizen under the right to information has a right to request the government for such information. Files, documents, electronic records, and such cases. Okay? The intent behind as all of this, as we've discussed, is to promote transparency and accountability in the functioning of working or the functioning or the working of public authorities. Okay? Now, the next question that comes is, who is included in the ambit of public authorities? Now, public authorities include bodies of self-government established under the Constitution, law, or any government notification. Basically means Article 12. So, for instance, it would include ministers, PSUs such as GAIL, such as BSNL, and also regulators such as SEBI, such as TRI, such as IRDA. It also includes any entities owned, controlled, or substantially financed by the government, and also NGOs which are substantially financed or indirectly funded by the government, which is basically Article 12. Anybody who could largely be called the state under Article 12 is also interchangeably public authority. For the purposes of this exam, you don't have to understand the technical difference between this. Okay? Now, the next question becomes the enforcement of right to information. The Right to Information Act provides for a three-tier structure for enforcing the right to information guaranteed under the Act. It provides for a three-tier structure for enforcing the right to information guaranteed under the Act. Okay? This means public authorities, the first tier is public authorities. Okay? Public authorities will set up an office within themselves, will designate some of their officers as PIOs, public information officers. This is not the same thing as persons of Indian origin, don't get confused. A PIO under RTI means public information officer. This person is appointed within an organization. So the Coal Authority of India Limited will have a few public information officers whose job is to answer RTI requests that come to the Coal Authority of India Limited. Okay? The first request goes to the central or the state assistant public information officer or any such officer which is designated by the public authority. Okay? If it's a central government, then central government organization, then a central government officer. State government organization, then a state government. So this PIO becomes your first entry point. The first application is sent to the PIO. These officers are required to provide a reply within 30 days of the receipt of the application. Okay? If the PIO declines it, says we can't give you this information because it is sensitive, it affects national security, it is classified in nature, and you're not happy with that decision, like any other court. If you're unhappy with the decision of the district court, you can appeal to the High Court. If you're unhappy with the decision of the District Consumer Forum, you can apply it to the State Consumer Forum. Appeals from their decisions will go to an appellate authority. Okay? Appeals against the appellate authority go to either the State Information Commission or the Central Information Commission. Okay? Either the State Information Commission or the Central Information Commission. So your three-tier structure becomes, you first send a request to the Public Information Officer. This person denies it, you're not happy with it, or gives a judgment. Okay? Or let's say gives a reply. You can then apply to the appellate authority which is set up. From the appellate authority, you have two choices: State Information Commission and Central Information Commission. State Information Commission and Central Information Commission. Now, depending on the nature of the RTI, depending on the nature of the organization, would your RTI lie before the central or the state? If it's a state authority, a state government authority, then State Information Commission. If it is a central government body, then a Central Information Commission. So this is largely the implementation procedure. If they do not reply within 30 days, then of course, yes, the officer can be penalized financially as well. Okay? All right. Now, the RTI Amendment Act of 2019 made certain key changes to this structure. Okay? There were certain key changes which were made to this structure and that fundamentally compromise the very idea of RTI. So let's look at it. Okay? First, so if you want, you can make a table out of this to understand this better. We will now look at the amendment structure. Let's look at the first. The first problem is with something called term. Okay? With something called term. Now, first things first. The Chief Information Commissioner and the State Information Commissioner, which is the Chief Information Commissioner at the central level and the State Information Commission is at the state level. Their terms have been mentioned under the RTI Act originally, and the term was 5 years. After this amendment, this term has been removed and it has been decided that the central government will decide the term for both Central Information Commissioners and your other information commissioners. Okay? Central Information Commissioners and other information commissioners, which means your State Information Commissioners. So, State Information Commissioners are also called Information Commissioners. They're the same word. This means that the information commissioners, the officials who are supposed to ensure that the information is released to the people, they do not enjoy security of tenure. They will now serve at the pleasure of the government and they may be removed at any given point of time if the government of any nature is unhappy with the kind of decisions that they are taking. The second problem lies with something called salary. Okay? With something called salary. Okay? Now, when we look at salary, this is the problem. The salary of the Central Information Commission, with commissioner at the central level, and the information commissioners at the state level were to be equivalent to that of the Chief Election Commissioner. Was to be equivalent to that of the Chief Election Commissioner. They were given the same kind of status and treatment. But the new amendment removes this. Okay? It is no longer the case. Like in term, the central government would decide how much salary has to be paid to the Central Information Commission and the Information Commissioners, which largely exist at the state level. So that's the larger idea, that the Information Commissioners here used to be treated the same way. They were not constitutional bodies, they are never a constitutional body, but they were given the same kind of treatment because of how important a function they were continuing for democracy. Because the larger idea was, people would ask a question. For example, let us say I file an RTI asking how much of the work has been completed under, let us say, Sagar Mala project. Okay? And I gave it to the PIO. Now, the PIO, before it could release, the PIO said, this is it. Now, when the PIO released the RTI reply, the central government said, you can't release it. They appealed against the PIO's decision. Okay? Now, I went to the appellate authority. The appellate authority also declined to give me information. Then this went to the Central Information Commission. But the Central Information Commission said, no, We must tell the people that yes, you should know how much of work has been done under Sagarmala. Now, this person will not feel free to, because the salary and the tenure of this person has been decided and has been conditioned to the government. And that's the larger idea behind the larger ecosystem. Okay, clear? Now, in addition to this, there have been a minor change which have also been spoken about. So the larger idea is, for example, deductions in salary. So apart from these two, the original was, the Act states in the RTI Act, the Act states that at the time of appointment of the Central Information Commissioners and Information Commissioners, if they are receiving pension or any other retirement benefits from previous government service, the salaries will be reduced to an equal amount to that provision. This means these previous government services would include central government, state government, corporation, and companies owned or controlled by the central government. This basically meant that, for example, you are a retired bureaucrat and you are getting a pension of 50,000 rupees. Okay? Now, your salary as an information commissioner at the state is going to be 1 lakh rupees. But what you will finally get is 50,000 rupees as salary, because you're already receiving 50,000 rupees as pension from the government. Okay? Clear on this? So this is the larger idea behind what is called your RTI provisions and stuff like that. Now, one of the key problems is, the government happens to be the largest litigator here. Most of the decisions that are appealed are actually appealed by the government, because the government doesn't want the people to know whether certain information should be declared or not. Okay? And very recently, the Supreme Court also had given a judgment where there was a conflict between RTI and RTP, right to information and right to privacy. Now, in such a case, what you needed to understand was, the Supreme Court said, if I am releasing information about a public official, that information should not be violating the right to privacy of the same public official. So a balance has to be made. So let us hope that the government does not abuse this provision, does not abuse this interpretation of the Supreme Court. Because the larger idea is, the government stores a lot of personal information on individuals. This could be anybody. It could be income tax returns, driving license returns, etc., etc. Now, this is very interesting to notice, because there have been several instances, for example, where the Highways and the Transport Ministry has been selling vehicular data to companies for better marketing and targeting. Now, if I own a vehicle, that data about my vehicle is my private life. I would not want the people to know what vehicle do I own, how long have I owned the vehicle, how have I bought it fair and square, have I taken a loan on the car. So it could apply on anybody. So the Supreme Court has said, personal information can be denied if it infringes on a person's right to individual privacy. So this are the recent developments, and this is largely how right to information needs to be covered. The most important part, the part that was missing. Okay?